Dickinson County Jail. His attorney is Robert Percola, who is present here in the courtroom. The people appear to Prosecutor Lisa Richards. We're here today on a motion that was filed today for modification of bond by Mr. Percola. Mr. Percola, as to your motion, please.
Thank you for accommodating our request and allowing us to address the court on this issue. Mr. Zanon has been in jail for 21 days at this point. He was arrested on August 12th. His second alleged bond violation in this matter, which is scheduled for hearing next week. I'm asking that the court consider giving him a personal recognizance bond or a bail amount so he can be released from jail at this point in time. As indicated, has any criminal history. His family's in the area, he grew up in the area, went to Norway High School, recently graduated. So get back into some work that may be available for him if he weeks. He's never had any kind of court proceedings, hasn't missed any, other than the allegations of bond violations, which obviously, but I would put it to the court that the amount of time he spent in jail has been enough to get it through to him that the seriousness of the bond, what those things mean. I think any lapses that may have occurred in that realm are down to the lack of security matters that I can assure the court my discussions with him until this point are now crystal clear in his mind. I would note that his mother, Brooks Zanon, is here in support of him and is able to offer that he have a place to stay at him always. Should be released. I know when we first had the agreement on this matter, Your Honor, we had asked for the court to allow Mr. Zanon to reside with a friend in Niagara because it was closer to his work. Perhaps that's not the greatest idea at the moment. So if the court were to release him, I think it would be appropriate to have the bond reflect, that more typical living arrangement with his parents rather than what had been previously authorized. Likewise, as we had requested at our previous request on this matter, the court thinks that a soberlink tether would be appropriate. I think it might be, again, given the allegations that are at play here in the bond violation. If there is an issue, it seems to be potentially one with alcohol, and I think that would provide a clear and direct means of supervision for the court to monitor that aspect. And if my beliefs that it's crystal clear in his head prove erroneous, then that will be painfully obvious when it happens. So that is our request at this time, Your Honor. Thank you.
Thank you. Ms. Richards, on behalf of the people.
Your Honor, as the court knows, we were originally scheduled for a trial on October 7th. Because of the bond violation, the court did move the trial up by almost a month. And we have finally successfully scheduled our motion to join these matters for trial. We had to do that on two different dates, the first being September 14th and the second being September 20th. Mr. Zanon's motion is scheduled for the latter of the two, which is clearly beyond the scheduled trial date. So at this point, Your Honor, the people are quite simply, we're not in a position to proceed to trial, and would be a week from next Friday, I believe. So given the fact that our motions will not have been heard by that point in time, so we are leaving the decision within the court's discretion with those points of consideration.
Well, in respect to the matter, as I went over this, like I said, a couple of times on the record now, when I first met with Mr. Zanon when he was here for arraignment back with everybody else in his situation, all of the co-defendants, I went through each and every one of them with my expectation for behavior as I was releasing them on bond, warning each of them if they violated the terms of their bond, they would be sitting in incarceration pending their trial. But I took these charges very, very seriously. I heard allegations through the courtroom that day of different behavior that was allegedly going on, continuing in harassment of the victim. I've not seen anything filed by the prosecutor's office. I have received some various pieces of paperwork from the community regarding posts and other types of things that have been sent into the court, but there's not been any other charges filed. However, Mr. Zanon, that day that I first saw him, I told him very clearly that basically, one, he had a new job at the Road Commission, two, that he had not been warned about any bond violation resulting in incarceration prior to his trial date. So I was going to let him go that day, even though he was back already on a bond violation for drinking alcohol, even before he made his first court appearance. But I warned Mr. Zanon very carefully that the key was in his ballpark, the key was in his hand. If he wanted to continue to drink and do other things that violated the terms of his bond, he would most definitely find his way back to the jail. Apparently, Mr. Zanon didn't take that very seriously because just days later, on August the 12th, he was back in Wisconsin possessing alcohol and consuming alcohol. So Mr. Zanon has been sitting in the Dickinson County Jail since that point in time. I've moved his trial up to September the 12th because our legislators have required that if somebody's in jail on a misdemeanor, they need to be brought to trial within 28 days. Straight out of the words of the prosecutor's mouth, it's very difficult to get somebody to trial in 28 days, especially cases that are this complex with this many co-defendants, this many issues arising. But far be it from us, we enforce the rules, we don't make the rules. So, here we are. Mr. Zanon, you're not going back to Wisconsin, I can tell you that much. If you go back to Wisconsin, you'll go back to the jail. That's night and day, black, white, yes, no. Am I clear?
Yes, Your Honor.
No back to Wisconsin, no drinking. I'm amending the bond. The underlying bond has permission to go to Wisconsin for work, residency, and court appearances on the condition that he sign a waiver. Well, actually, that box wasn't even checked, to tell you the truth, it should have been. But he's no longer able to go to Wisconsin.
You know, could that just be slightly modified?
No.
Unfortunately, because of those issues, he does have a court appearance coming up in Wisconsin.
When?
September 15th.
All right, that only. He can go into Wisconsin for court appearances or to meet with a lawyer. Only those reasons. It was checked on the 629 one. I don't know why it wasn't done earlier one. The amended bond here. On 629 allows that. So we're revoking that provision in respect to the bond on the bond violation. That's what he's sitting lodged on. So the order of the court is as follows. All right, Mr. Zanon, this is what I'm going to do. I'm going to amend the bond to allow you to be released on a $5,000 personal recognizance bond, but it's contingent on one, you're not allowed to go to Wisconsin. Two, you have to be on a sheriff's tether at your expense.
Yes, Your Honor.
I don't know if they have any units there or how long it's going to take them to get one, but when you get one and you're signed up, then you can be released. If I get wind that you're drinking or doing anything wrong, harassing this victim, doing anything out of perfect conformance of behavior with your bond conditions, Mr. Zanon, you know where you'll be back.
Yes, Your Honor.
Do we have a meeting of the minds now? You know what I expect of you.
Yes, I do, Your Honor.
All right, then, in respect to this matter, otherwise, all of the terms of the bond remain in place. You're subject to random PBTs and drug screens. Don't be surprised that you don't get calls, Mr. Zanon. We're going to be checking on you.
Okay, Your Honor.
So he's going to go home and live with his mom and dad, or his mom, one of the parents, anyway. All right. So, Mr. Zanon, make sure that you stay in touch with your lawyer. Make sure that you toe in the line the way you need to here. In regard to the trial that's set for the 12th and the 13th, you wish to be heard on that issue then, Mr. Perkle or Ms. Richards?
Your Honor, given the court's decision today, I would ask that, the case be scheduled for the original trial date of October 7th.
I don't know if we even still have that date.
Oh, that was just like a.
Oh, that was the cattle call date. All right, so Mr. Perkle, do you wish to be heard?
Well, again, I don't know, in terms of the sheriff's tether, if there isn't one available under your ruling, still be in jail and still subject to the 28-day rule, so.
Let's leave the 12th and 13th on. That's my feeling too, in an abundance of caution. If he's out in the meantime, we can all assemble on the drop of a hat like we did today, and or by phone, and get the matter moved. But in the meantime, we'll keep it on for the 12th and 13th.
And could that be sheriff's tether or soberlink?
Well, my problem with the soberlink is we don't have any pretrial staff here. I'd love to do it, but now it makes the probation department have to wear another hat and go to pretrial services. So that's why I am saying the sheriff's tether. If I will say, if it's available, we can do the soberlink, but my preference is for the sheriff's tether for that reason.
That's something that the sheriff's office would monitor.
The tether, yes, that's on the sheriff. And the cost is on him no matter what. All right, Mr. Zanon, don't disappoint me.
I won't, Your Honor.
All right, anything else this afternoon on the file, Ms. Richards?
No, Your Honor.
Mr. Perkala?
I don't believe so, Your Honor. Thank you.
All right, thank you. Mr. Perkala, I signed your other order. Was that your case on Pete Antonio for tomorrow? No, it was Mr. Carlson's.
No,
All right.